One of the biggest mistakes that people make all the time in the restraining order court hearings is that they present evidence to the judge that they think is really good for them, that they think is really bad only for the other party, but actually is damaging for them, and it's difficult for them to see that and get that perspective. So in this video, I'm going to be explaining that so that you can avoid it, and we will also be going through some examples. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself in your restraining order hearing, and I teach you start to finish everything that you need to know to have your best chance. So if that is something that you are interested in, you can get your free first class via the link down below. Okay, so let's jump right in. Evidence that might be a double-edged sword. I see this all the time with my own clients where they will present evidence to me and I'm looking at it and I'm thinking, wait, this looks bad for you. Why did you give this to me? I mean, I'm happy to see it in advance, right? You know, if it's bad for my client, I would rather know ahead of time, but I'll talk to them and they'll say, well, this makes the other side look bad because of X, Y, Z. And I have to explain to them, maybe it makes them look a little bad, but it makes you look worse. It's more damaging to you. And typically I'm representing the respondent in these restraining order court proceedings. And so the respondent is just defending, right? So we want to poke holes in the other side's allegation. We do want to, throw some rocks at them and their credibility when we can, but the main thing is to focus on the fact that we are defending. So if I present a piece of evidence that makes the other side look kind of bad, the other side that's claiming that they're the victim of abuse, but makes my side look worse, then I have done a terrible job representing that client. And I mean, the benefit to me as an attorney or a human is I'm a third party, right? I can sort of zoom out and look at this objectively. It can be very difficult, though, when you are representing yourself to do that. And this is something I talk to people about all the time. I do these VIP strategy sessions, which there's also a link down below, where I do talk to people about their evidence. And sometimes I tell them, what do you think that proves? I don't think that you should use this. And I explain to them why not. And I think that that is a very valuable service. But I think if we go through some examples here, hopefully you can have a new lens to look at your own evidence through so that you can make sure that your evidence is not a double-edged sword that is going to stab you harder than it stabs the other side. So let's go through them. Example number 1, text messages. Let's say that you have text messages where the other party uses harsh language. They are swearing at you. They're saying things that I cannot say on YouTube. And you want to present these to the judge because it makes the other side look bad, right? They're using curse words. They are talking about you in a really negative way. So you want to use these text messages to show that the other side was toxic or maybe cast doubt on their credibility. But what about your responses, right? If you responded and you were about as bad, equally as bad, on the same level, then that is going to make you look even worse. And if you were thinking that you were just going to leave your responses out, just stop right now. Because these are communications between you and the other party. So the other party probably has them and is going to present them to the judge. And if the judge sees that you submitted only the text messages or emails or whatever, where the other side was a jerk and calling you names, but you left out all of your responses, your credibility is gone. And in restraining order hearings, credibility is everything. The judge only has to believe one side over the other by slightly more than 50%. So if you are only showing the judge half the story, they are not going to believe you. And you've probably lost the hearing right there, whether you are the petitioner or whether you are the respondent. Now, on that note, though, if you as the respondent saw that the petitioner has submitted to the court or is submitting to the court all the text messages where you say negative things, but not their response, which is equally negative, have those ready. Make sure that you have the petitioner's responses ready to present to the judge so that the judge can see that they are leaving things out and do not believe them. Number 2, surveillance footage. Let's say that you submit ring surveillance footage to show that the other party was angrily yelling at you on the porch of your shared or used to be shared residence. But this reminds the other person that they actually have access to the ring footage too, and they get other footage of you doing things that are much worse than whatever you have submitted. think about what evidence the other side might have, because generally you do not have to submit everything that you have before the hearing. Sometimes you'll show up, the judge will continue it, and the judge will say you have to exchange your evidence by such and such date. But if the judge doesn't, you want to really carefully think about what they might have brought with them that they might have access to. And I've even seen situations, I tell people, make sure you have your evidence ready, have it printed out, have it ready for the judge. But that doesn't mean that the judge cannot look at a message someone has on their phone just because they don't have something printed out. So if the other party realizes, oh, you only gave part of that conversation, or you cut these really important parts of the conversation out, they can offer to show that to the judge. And if the judge sees that, you are screwed. And that includes Ring video. You can access Ring video from your phone. So be very, very careful there. Number 3, medical records. Make sure that you read any medical records that you are planning to submit very carefully first. So let's say that you claim that in an altercation, a physical altercation, you were just acting in self-defense, and you present medical records showing that you were injured. Maybe you have a black eye, for example, and the medical records support that. But if you look carefully at the medical records, they also show that you had abrasions to your fists, to your knuckles, and had a BAC of 0.18, supporting the other party's allegations that you punched them repeatedly while drunk. Now, I have actually had multiple situations like this where I am the respondent's attorney. Petitioner gives us the medical records, and petitioner obviously has not reviewed them carefully and doesn't realize. So before you submit anything like that, be very careful and make sure that you have read it thoroughly. Number 4, evidence of violations of privacy. You provide emails or messages obtained by guessing the other party's password, aiming to prove harassment, or as the respondent that the petitioner planned this whole thing to get some other advantage. Accessing someone's email or phone without their authorization by guessing their password, or even if you already had it because they gave it to you, that is probably going to look a lot worse for you, especially as the respondent, than it ever will for the other party. It's not worth it. And I have had people submit to me evidence that shows the other person being the one who is logged in or being the one who's sending a message. And I have to ask, where did you get that? I'm sure the judge uses email and text message too. They will probably notice it and ask you how you obtained it, and whatever answer you give is probably not going to be good for you as the respondent. Number 5, you attempt to show that the other party is stalking you and tracking your movements by tracking them. So maybe you put a tracker on their car. And again, these are real life things that I've seen people do. You put a tracker on their car to show that they are monitoring you, or they've gone past your work or past your home as the petitioner. You did something far worse than just driving past by putting a tracker on their car. Now, if you're the petitioner and this is evidence that you've obtained and you're thinking, yeah, but I'm the petitioner, they haven't asked for a restraining order against me, I can submit whatever I want. Well, just because they have not requested a restraining order against you right now doesn't mean that they can't, as soon as you get out of court, literally go down the hallway to the self-help center that you probably visited at the same courthouse and ask for a restraining order against you, because now they have evidence that you put a tracker on their car, right? I hope you found this video helpful. I know that some of these are kind of extreme examples, but I hope that this helps you view your own evidence from a different lens, to think, how could this hurt me? Because especially as a respondent, again, it is all about defending. It's about addressing the allegations against you, disproving what you can, and presenting yourself as a credible person in front of the judge. And remember, if you are planning to represent yourself, you can binge watch YouTube hoping to find the answers. You can watch every video that I've ever posted on YouTube on restraining orders, but it will probably take a long time. You will get bored, and you can get all the answers served to you on a silver platter from start to finish, everything you need in the course. So go get your free class down below if you're thinking about representing yourself. And if you did find the video helpful, please don't forget to like, subscribe, and ring the bell.